The world turns, and with each turn, a change. And each change makes it more complex, unpredictable, enigmatic. The world keeps turning. And from the Pellicer and Heredia practice, we anticipate everything that is going to happen. Brexit, artificial intelligence, new commercial borders, legal tech. The world keeps turning, and it commands the reliance on international lawyers who are capable of interpreting this new reality with integrity, honesty, and transparency, offering answers to so many new questions. Whatever it is, ask us. At Pellicer and Heredia, we know how.
Hello, good afternoon, everyone. I hope you're having a good time in July. I'm happy today to get back to all of you talking about possible fiscal scenario of your resident permit in Spain. The whole thing is being started because now with so many questions about your visas, your residencia, a lot of questions, a lot of people don't know the rules. And then we considered that it was quite interesting to talk a little bit about these possible scenarios and for you to take the most out of this webinar. I've got on my left-hand side here, I've got Pedro Heredia from Alicante. Hello, Pedro, can you hear me?
Hello, Ignacio, I can hear you perfectly. I can see you very well. How are you doing?
Very well, from a little bit of the lockdown I'm in, and but very much willing to see you soon, all of you. Okay, I've got on the right hand side Michael Davies. Hello, Michael, in Almeria.
Hello, Ignacio. Hello, Pedro.
How are you guys doing in Almeria? Keeping
well?
Oh,
very well, very well. We're all good. I hear you're in lockdown, yes, for a few days?
Yeah, I've been very bad boy, and now I need to be at home. So. Children did something not good, and then I am to be punished here. So let's see how we move on with COVID restrictions and all these things. Now let me just do a brief explanation where we are, because Michael, I don't know whether you, I'm sure Pedro did, are having a lot of questions about fiscal residency. And now all mixed with the residency permit and tax implication, because one goes with the other, okay? So if you wish, we could start talking about the type of residency permits and all the possible scenarios that people might end up dealing with the tax office, okay? I'll be very brief, and I'll pass it to Pedro and then Michael, and then we'll try to jump into questions. Please feel free to send us your questions. I know there will be complex questions and probably will not be able to answer today. We could do, Michael and Pedro, if you could leave your details and even mention here later on in voice your telephone number, because the chat will disappear later on for those who will be listening later on. Okay, now, for those who are listening from abroad or even people from here, I just need to send them a reminder. There is a dual taxation treaty between UK and Spain that's been already signed many years ago, 1977. It's being refreshed now in 2015. There is exchange of information between two countries, and it's important for you to at least read it if you're planning to move on through here in Spain. And if you're planning to become fiscal resident in Spain, it's important for you to do simulation with your advisor about what possible scenarios you're going to face when you come to Spain. Even if you are here and it's the first time you are doing your tax return, it is important for you to understand the system. Now, if you come over from abroad, even for those who are British, for those who are Americans, non-European citizens, you will be coming over to Spain and you will get a permit. Or you will apply for a permit from the consulate, and you will get a residency permit. Probably it's 1 year, you will renew for 2 years, 2 years, 5 years, permanent, okay? It will be the non-lucrative visa, the golden visa, entrepreneur visa, work visa, etc., etc. There is even a social ties visa, etc. Now, for those who you are going to stay here more than 6 months in Spain, it is important for you to be careful doing the right tax return in Spain if you're going to stay more than 6 months. There is some scenarios where you'll have your residency permit, let's say even non-lucrative visa in these days, and even probably stay less than 6 months. Obviously, you need to understand there is two different regulations. One will be the immigration system, one will be the tax. They are connected, but they're not linked. Okay, so we need to work very much on the evidence side. It's good for you to keep the tickets. It's good to keep the certificates of non-residency in one home country, and to work out your specific situation. Now, what we're going to do is talk about the dual taxation treaty. Article 4 will explain to you what is considered to be tax resident in Spain. Once you're resident in Spain, which means that you stay more than 183 days, you will start lodging your income tax return. You need to do the 720, obviously from January to March. Then from April to June, you'll need to do the income tax return and wealth tax return. Then non-resident tax will be from January to the end of December. Now, important thing, one thing is your residencia permit, and the other thing will be the taxation. And it's very important for you to be clear. We're having a lot of questions about non-lucrative visa, which the regulation by itself obliges you to stay more than 6 months, and even being non-tax resident, or even the situation with a TIE and being non-resident. So it really needs a specific advice and understand, according to the dual taxation treaty and according to the rules, whether that's a possible scenario and what kind of evidence you will need in case the tax office sends you a letter. Okay, I'm going to pass over to Pedro now, just for him to just briefly give us the differences on the type of visas, TIE visas, and then later on, Michael will tell us what is to be considered as a non-resident. So, and then we'll jump on as soon as possible with all your questions, as much as we could answer today. Okay, over to you, Pedro.
Okay, Ignacio. Well, just to be brief, obviously, as you've said, it is duly linked. Whatever is going to apply for residence or is going to obtain a visa in order to be authorized to be resident in Spain, obviously there is something involved, which is taxes. When someone becomes resident and will become tax resident, then will be obviously attracted in order to declare the worldwide income in Spain. What income has to be declared and what taxes needs to be done, and obviously will be focused on the double taxation treaties, as you said, between Spain and, I would say there are around 100 agreements between Spain and different countries. Some of them, just a few of them, I think it's around 8 right now, is being renegotiation. And obviously the immigration issue is absolutely linked into the taxes. What kind of, obviously this needs to be defined, what is resident and what is, as has been said, to be tax resident. Well, the principal rule is that you stay in Spain more than 180 days. This is the principal rule, the standard rule. But obviously, when you are resident, obviously it is presumed that you are tax resident, or you will have to declare your worldwide income. Firstly, the entrance door is the immigration. What kind of visa, what kind of immigration's vehicle guides are you available in order to enter Spain? Well, there are some of them. We're going to focus. Well, the latest one, I would say most of the way we are receiving questions. As United Kingdom has right now leave European Union, obviously right now it's a third country, and as a third country, the queue in order to apply for immigration is different if it were a European Union country. So under the Spanish immigration rules, there are like two different queues: European Union and third countries, non-European Union countries. Under the non-European Union countries, obviously there are some vehicles like work permit, but let's focus on the non-lucrative visa, which I assume is probably the most common right now for UK citizens that are retired and would like to start the retirement and applying for residency in Spain. Obviously, there are different ones, and other ones like like the work or through a company, that as an employee, but let's focus on the non-lucrative visa. Ignacio? Okay, I think it's right now what we are receiving most of the questions on, and obviously it is involved the taxes and also because as when someone applies for non-lucrative visa, it's involved to be resident, and it is involved that you are tax resident. Well, first thing about non-lucrative visa, it is forbidden to work. This is the rule. This is theoretically the rule, but also I would have to say that obviously this is focused in order not to, let's say, reject any employment in Spain or to work in Spain into a Spanish company into our work in Spain. Can be this done remotely? Can someone apply for an lucrative visa with the forbidden to work notice and work remotely for a different country? There is no rule, but I would say yes. But the main things really, in order to apply for a non-lucrative visa, I would say there are 3 pillars really. Well, principal rule is that you are not allowed to work. Second thing is like financial means. You need to show that you prove financial means, savings, funds, access to some money or monthly period money that you receive guarantee, not from work, from guarantee, from like pensions, for example. So you need to show that you have enough money to live in Spain for the first year. 1 year application, then it's plus 2 years and plus 2 years. So in the first year application, you need to show as a principal a minimum amount of savings that you have access to 27,000 euros. That's one person, 2 people, or every family member that we add into the application will be plus 7,000 euros. For example, if there is a married couple, will be a principal, one of them, and plus the other one, 7,000. So 27,000 euros plus 7,000 euros as a minimum. That will be 34,000 euros, showing that you have access to those savings in order to prove that you have enough financial means to be able to live in Spain. Then is the insurance. You need to show and prove that you have access to health system or private system. At the beginning, we always recommend, unless there is a right to have access to public system, we recommend to go to the private system with insurance, with a different kind of companies that do that. And you have to get the policy for 1 year with hospitalization included and without any copayment. And the third document, I would say, is really the criminal records. I mean, obviously there is the last 5 years without any criminal record. And that's important. All the documents which are public documents needs to be legalized with the Apostle of Hague Convention and then duly translated into Spanish. Apart from that, there is a medical certification, a copy of the passport. Well, some other documents that are more standard and I would say less important. But this kind of visa, whenever you, as I said, you apply for 1 year and then plus 2 years and then plus 2 years. In order to renew it, you need to show that you've been resident in Spain. And to be resident in Spain, you need to show that you've been living in Spain more than 183 days. Because without that, you will not be renewed. So you will not renew for the following 2 years, which means that if you obviously renew and you stay more than 183 days, obviously you will be in some way tax resident in Spain and will be attracted the obligations as a resident and as a tax resident in Spain, which means worldwide income, which means probably Modelo 720, which is an informative declaration that you have to show assets, values that are more than 50,000 euros, and probably wealth tax. Well, these declarations that should be done once you are tax resident. Ignacio.
Okay, Pedro, thank you very much. We'll just comment. We've got a lot of questions already in the panel. I think we're being inundated here. I will pass over to Michael now to tell us what about the non-residents and his thoughts about all the whole thing. Over to you, Michael.
Excellent, Ignacio, thank you. It's great to speak to an expert like Pedro on the visas, because in our office we don't handle the visas and things. As you know, we specialize mainly in inheritance work, but it's very interesting to hear Pedro. And I've got a question for him. I'm going to ask it because I think lots of people are asking this question. It may be, I was very straightforward for Pedro, but just to clarify, the 27,000 euro, which is the minimum requirement that you've got to prove that you have access to, Does it need to all be in your bank account, or can you, for example, show that you've got a monthly pension that adds up to over the 27,000 during the full year?
Yeah, this is a matter of proof. Obviously, this is not a rule saying that. It's financial means that you need to show that you have access to that money. Obviously, if it's a pension, that you're going to receive more than that amount that year, that would be sufficient proof. At the end, you need to show really that you have that money. Is like guarantee money, or you have that money. Obviously, it's never guaranteed, 100% guaranteed, but you have access to that money during the first year.
Okay, so if it's a pension coming from England, I can see obviously if the money was all in a Spanish bank account, well then you show a certificate from the Spanish bank. If you were going to rely on saying that we've got a pension coming in every month, it's going to add up to more than 27,000. I presume we have to show what the pension documents and have it translated, perhaps, and Hague's apostille.
Yeah, exactly. I mean, I would say that pension documents, if it's a public or if it's private, I mean, obviously duly translated. If it's public, also with legalized. But duly translated to show that this is the pension value, or this is the monthly payment, or this is the amount every year, where it shows what is going to be received. It doesn't have to be. It doesn't have to be really in a Spanish bank account. The money is going to go to the Spanish bank account. It could be also in the UK. At least you need to show and prove that you have access. So if you are living in Spain, even though the money is in UK, you have access to that.
Okay, so I presume though it's more straightforward. For example, so if somebody approaches you and wants to get their residential, etc., I presume it's more straightforward if they can do it to have the money just in the Spanish bank account. Yes, and only if that's not possible, then they could go on to the pension route and things like that.
Yeah, at the end, yeah, that's right. I mean, it's, as I said, it's a barrier of proof. Obviously, if it's in a Spanish bank account, the credibility, obviously, because of visa chiefs, in order to revise, is in the bank, is in Spain. The connection with Spain is higher because I mean, the money is here in Spain. So at the end, the proof is higher. This is a subjective, really, criteria between some visa chiefs in some Spanish consulates and other. So, but obviously, what you've said is correct. I agree with that.
Yeah, I say this because, I mean, in your case, you are experts, and you know that sometimes, as my granny used to say, a little knowledge does a lot of harm. And, you hear people, say, well, I've been told that on the internet I don't need the money in my bank account. My pension from the UK or from my employer, that will be sufficient. It's all true. But of course, the easiest thing is to have the money in a Spanish bank account, because you won't have to actually prove beyond doubt that you are going to have access to that money. So that's sort of that. Okay, so sorry to interrupt you there. I thought
it's okay.
You get into these questions, so I thought let's ask you straight out, the expert, and then we can put it to bed. Okay, with the non-residents, the situation for non-residents in Spain, for UK non-residents, is very similar to what it was before Brexit. Except for if you rent out your property, you're not going to be able to deduct the expenses of running the property and deduct those expenses against the gains. So you'll pay on the full gross rental money and not on the net profit of the rentals. That's going to be the difference. So basically, if you're a non-resident and you're not renting out your property, the situation is exactly the same as before. Once a year, you file your 210 form, which you normally do through a solicitor or through your accountant. Normally people do it through the solicitor to handle their conveyance, but you can do it through any accountant. It's not very complicated. A 210 form, and you basically what is called non-resident imputed income tax. The taxman considers that you make a small amount of income even if you don't rent it out, basically on the basis that they just think that people do so every now and again and don't declare it. So what they do is they take 1.1% of the catastral value that appears on your rates bill, and they tax you at 24.75% of that. To cut a long story short, basically, if you have a flat that's worth 200,000, you'll probably pay anywhere between 300 and 500 euro a year for this non-resident imputed income tax. The important thing to take away on this is that if you own a property in Spain and you are a non-resident, apart from the electricity, the water, the rates, the rubbish, and the community of owners that you'll be paying by direct debit, once a year, you must file a 210 form via a solicitor or accountant, and you could even try and do it yourself, but I don't recommend it. But just remember that if you've got a property in Spain, you're not renting it out, and you're a non-resident, if you don't have someone that writes to you each year saying you've got to present your 210 form, you're missing something out. So you need to speak to your solicitor or your accountant and see what's going on. At the end of the day, if you haven't been paying it, there are very few people that are not nowadays, but if you have not been paying it, the maximum they can claim now is 4 years to the statute of limitation. Put that in good order. If you are renting the property out, then what you do is every 3 months you have to declare the real income that you've received and pay tax on that amount. And unfortunately now, since Brexit, you cannot deduct the expenses, the running costs of the property. So you obviously end up paying more tax. For those days that you don't rent it out, you have to pay the non-resident imputed income tax, the one I mentioned before, but proportionate just to the days that you haven't been renting it out. And that's it in a nutshell for non-residents. The situation for non-residents is very simple and hasn't changed that much. Even though if you, for example, have 3 or 4 properties and you're renting them out, because of the fact that you can't now discount the expenses that you've got for running those properties, after 3 or 4 properties, it starts becoming interesting maybe to form a Spanish SL company to be able to deduct the expenses. So less than 3 properties, you have to bite the bullet, pay your non-resident tax on the full rental money. If you've got more than 3 or 4 properties, speak to an accountant or a lawyer do some number crunching to see whether it may be interesting for you to form an SL company in Spain. I think that's it, Ignacio. I don't know if there's anything else you want me to talk about. That's just the non-resident tax situation, obviously, at the moment.
Okay, thank you, Michael. Very interesting and good advice. And more than ever, as we said, tax planning is key here. As Michael say, you need to work out your numbers, whether it's worth it to create an SL or become non-resident. Every scenario is different, but we're trying here to give you the general bullet points here for you to understand. But there is still a lot of people that need to know how to use and implement the dual taxation treaty, how to be able to prove your status, just in case, because of the exchange of information, you get these kind of letters that we don't like, and we need to answer straight away. And my biggest stress is to be able to answer with the clock ticking, So that's basically the advice here. Now I'm going to pass over to Juan Fran here to give us just 1 minute video, see where we are at the moment. And then we're going to jump on straight away into all the questions as fast as we can, so you can have all the answers. If we don't have the time, we will organize.
You can't stop thinking about it. That hidden cove, just for you. That little hideaway in the mountains. Or that beautiful postcard town. Dreaming about enjoying the fresh air again. Feeling the sun on your skin. Exploring, walking. Traveler, there is no path. Paths are made by walking. Never stop dreaming. Spain will wait.
Okay, thank you, Juan Fran. It's nice to know nice cities where to visit, and I hope, I don't know if you're coming or you're already here, could have a nice summer enjoying. Now, we're going to start with Bill, and Michael and Pedro, please feel free to jump on and do any comment as relevant, because we are having hundreds of consultations about a lot of topics, and I think it's important to share the information here. Let me just say, we've got Guillermo here, the accountant, with us as well, just in case we need a little bit further details. Pedro, would you like to start with?
Yeah, let me read the, you said Bill, let me just find it.
Yes.
Okay, we're here. How is gold bullion treated under the Spanish wealth tax. Okay, well, thank you, Bill. I mean, obviously, gold is just the value on when you bought it. I mean, in order to be treated in wealth tax. So this is the answer, really. I mean, how pensions on IRA plans treated under the wealth tax? Well, pensions are exempt on wealth tax. That's important. I mean, between IRA and which is a traditional IRA or IRA, and Roth IRA. I mean, the difference, Ignacio, let me just make a difference about the Roth IRA and the traditional IRA. The Roth IRA, you invest some money, you don't get some like, you don't get like some benefits. So at the end, you pay some income, and whenever you withdraw it, you will be tax-free. And the traditional IRA, you make some payments, you get some benefit, and whenever you withdraw, you will pay some taxes. The plans or the IRA and pensions is not. I don't see that it with our criteria is that either an entry do not entry on the wealth tax, but the Roth IRA, in our opinion, in my opinion, is should be included in the wealth tax. And will a tax residency certificate from a third country take precedent over the 183-day rule? Well, the 183-day rule is, I would say, is a must. If you spend more than 183 days in Spain, that you will be tax resident, unless you confirm some specifications that you are. I mean, your central or everything, finance, everything is done outside of Spain. But if you spend more than 183 days in Spain, then you will be attracted in order to declare and pay taxes accordingly in Spain.
Okay, thank you, Pedro. We're going to just, and please again, interrupt me if you consider, Michael or Pedro, that you need to add anything else. We're going to go now down with Alison, and this is pretty much a scenario. We're a pensioners couple with homes in Spain and UK, and close family in Belgium, where we spend time each year. In 2009, we obtained green resident certificate on advice, as we spent more than 90 days in Spain. We have always declared and paid income tax in the UK, or the UK generated. Have a non-resident bank account in Spain and pay non-resident property tax there. Since Brexit, we had used our green residency certificates to obtain Spanish driver license, and with S1 forms, permanent SIP cards. Having spent the summer months in the UK, we plan to exchange our residency certificate for the TIE cards when back in Spain in September. Are we doing anything illegal? In a normal year, we would expect to spend 150 days in Spain, 150 days in the UK, and the remainder elsewhere in the EU. We hope we are legal non-fiscal residents in Spain. Okay, that's a very good question, Alison. Now, the situation that you're not going to stay in Spain more than 183 days rule. Okay, so the straight answer to you is you're doing everything correct, you're non-resident, and you're not staying here. Now more than ever, is good to keep track and evidence. As Michael stated before, they could go back to you 4 years. There is exchange of information, obviously from some time ago, from 2015, with the two countries. And I don't know if it happens to Michael down in Almeria, but a lot of clients are receiving letters saying, and even sometimes they're wrong letters, because the period of time in the UK goes from April to April, and Spain goes from January to December. And sometimes they even get these things wrong, and they just send letters for you to do allegation and reply. Okay, yes, Michael?
Ignacio, yes. Let me be the voice of the listeners, because I know it's going to sound a bit, it's going to baffle some people, but I'm lost. Okay, I'm lost. I don't specialize in visas anyway, but I have to say I'm very confused about a situation like this. Okay, because I mean, if you obtain a TIE number, there is sort of a very strong presumption that you are a tax resident in Spain, a very strong one. So these viewers, they're obviously not going to spend more than half the year in Spain, but they're getting their TIE number. So how is it going to work for them? I mean, it's perfectly possible that they received a letter from the tax office saying, we think that you're a resident in Spain and therefore you should be presenting your income tax returns in Spain. It's perfectly possible because by obtaining the TIE number, they've sort of, if you like, put their head in the lion's mouth, and there's going to be that presumption. So how difficult or easy, if anybody knows, is it going to be for them to actually escape that situation of the taxman considering them a tax resident, especially as in their case, where they don't actually spend more than half the year in any other country, because they spend 150 days here, 100 days in the UK, 30 days in Belgium. I'm not trying to be difficult.
That's very good.
It's a question I myself don't really know how.
Yeah, Michael. We probably could give you a little bit of light here because we've been dealing with certain inspections on these respects.
Yes, absolutely.
And we could tell you how good it went, and we don't know how good it will go in the future or bad. Okay, we could tell you.
That's what I'd like to hear. Yes, perfect.
Right, right. Okay, as far as I can recommend here, for those people, actually for Alison, I would recommend her to always keep and apply a certificate, a fiscal certificate from their home country. Why? Because if you read the dual taxation treaty between Spain and the UK, specifically in the UK, but there is more treaties in different countries if you listen from different countries, there is exchange of information. And Michael, one side you've got the immigration saying that you stay more than 90 days, but not necessarily you're spending more than 6 months, right? So I fully understand because you're following the regulations of the immigration law. Yes. As you might understand, we've got immigration, social security, tax office, all the three, but not working together. They're there. They exchange information all between. But
like the viewers need to understand that as the first point to basically understand the rest of the explanation. I think they're independent and don't necessarily work together.
Yeah, that's correct. And that's at the end of the day, Michael. This is like a court case. Is disclosing evidence and them having evidence. And that's really the whole case. When they serve you a letter, they're saying, okay, we are aware that you've got your TIE. Okay, good. Here we go. I've got my tickets. Okay, but you've got the TIE and and they are in connection with the water company, the electric company. You know, they have a lot of information. Yes, I cannot remember how many sources of information they have, but there are many. Now, the situation, what we're doing, and it did work so far, you know, on the dual taxation treaty, if you read it through, and I think it's Article 24, they say exchange of information, but both countries, where there is a conflict, they will talk to each other. Okay, when there is a conflict. Sometimes what you really need to enforce is all these rights. For example, you've got a TIE and you stayed in the UK more than 183, or abroad more than 183, so here you're less. There is a presumption that you having a TIE, you are here in Spain and you're to be tax resident. How do I discredit this thing? Okay, I will recommend in these circumstances do a non-resident income tax return. I will recommend essential. And then I will recommend them if they are down in this kind of difficult situation to get every year a fiscal certificate in the UK where it says specifically, and we got it, according to the dual taxation treaty between Spain and the UK, you are considered to be tax resident in the UK. So here we go. When they serve you the letter, you show the tickets, you say you spend less time, there is a presumption. They say, oh, you've got the immigration paper, but that's not binding. That's only a presumption. So here you go. You send another letter saying, according to the UK or any country, you are a tax resident in that country. And then in case of conflict, obviously, the two countries should talk to each other. So far, Michael, nothing is being stress-free, but we managed to go through this procedure. Okay, as I said, one thing is the immigration, and obviously, if you don't comply, that's the immigration rules, not connected to the tax, but related. Then you have the scenario for social security people, for those who want to have the non-lucrative visa more than 6 months, but they work from the UK. Well, they work in Spain, but not for Spain. They work remotely, and they will be tax free. They will need to apply for tax free in the UK. and pay the tax here, pay the social security over there, do the tax here, comply with the regulations here. You see, it's a very messy field.
Yeah, it's just messy, yes.
It's very messy field, but there is a way, and a legal way to do it. But obviously, as I said, Michael, you need to be protecting yourself with evidence. If these people here have 150 days, they'll be able to, they will have to prove it. If in the dual taxation treaty, it says, if they're a resident in both countries, there is a different criteria. They're going to see where is the center of interest. For example, the treaty says a property in the UK, your main property, or the main property here. Some cases you have two. Which one is the one? And then the two countries needs to talk. As you know in law, to stop one administration, the best way to stop one administration is with a certificate from another administration. That will be my advice for those who are in a very delicate situation. However, this is not 100% secure because they could carry on digging. They could still contact the home country where you are and start digging and digging, saying why this or why the other. But the more evidence you have, Michael. So Pedro and myself, we've been just discussing, because with the immigration situation, we had so much situation like the one you are explaining, Michael. And there is a way. I mean, we couldn't say categorically this is the answer, okay, because it's specific, but you could start building on every single evidence. And if you, and the bullet points I will tell the audience today, the dual taxation treaty needs to be respected. The law here in Spain for 183 needs to be respected. And then if you could build up yourself with enough evidence to defend what you're saying and to prove that a different administration told you to do that, okay, that will be a good way of discharging yourself. And that procedure, Michael, could go into court, take to the High Court, etc., etc., etc. Actually, I think Pedro is dealing with a big case as well, and there are. I think he told me the other day that they are reviewing now everybody's 2016 income tax return, because they consider, for some clients, they considered they are offshore working, and they just considered, where are you based? Where is the center of interest? Where do you have the family? And that's very delicate, Michael, because your wife is here, your children are here, you are offshore. You need to be very careful, because there is a lot of evidence, and then you need to have some certificate. For example, Ghana, you need to get one fiscal certificate saying that you are paying over there because of that. So it's a very important question, Michael. It is impossible to answer that, but there is a way to protect. That will be, I don't know if Pedro wants to add anything else here because you really hit the bottom of the whole webinar, which is the key. What do we do with one permit and with one tax system in the other? Pedro, would you like to add something else?
Apologize, because I've been having some problems with listening to you, but obviously this problem is arising regarding, as I think Michael said, these people are getting the TIE, but are not being really resident in Spain. Obviously, are not being tax resident in Spain. This 183 days rule is not crossed. It stays less than that, but it's getting the TIE as a resident for 5 years or so. If he's not spent more than half of a year, what will happen after those 5 years? Will be reviewed or not? Well, I mean, obviously, what I think you've been talking about the presumptions, that is obviously that is a matter of proof at the end. It would be a court case, but I think there's a discussion on that really. And those people that are getting benefit of a TIE in order to be flexible to enter Spain, back and forwards, but are not being really resident in Spain on taxes because there are no more than 180 days. Would be a problem, I presume, will happen unless it's something that changes whenever it's going to be renewed. But yeah, but I think you have talk about all these points, Ignacio.
Yeah.
But Pedro, but just one thing, as I said, one thing. Let's sort problems out from the very beginning. The first thing you do is the immigration. So you might not comply with the immigration rules, and then you'll have to go through the process. And that's one side I will focus on. The other one is the tax. So for those who've got the TIE who are non-resident and they are able to prove they're non-resident, The situation is that might not comply for renewal, but that's a different problem.
That's
But
the issue,
not,
yeah.
not with the
right.
tax office,
Yeah.
is with the immigration.
You have the proof, that as non-resident has not been more than what it is today. Perfect. That's perfect. That will not be untaxed.
What I think though is that people, a lot of people have tried very hard to comply with the immigration side of things because they wanted to be able to move back and forth, freely, etc. And they have jumped into a situation without doing things correctly, and now they've got a problem with the tax office because they've done the TIE and they think, well, I'm resident, but really I'll still pay my taxes in the UK. And we've come across a situation which what we're going to do is we're going to recommend that they go and speak to you, because I know you are experts and we had a half an hour before the seminar. I know you've seen these cases, but we came across a situation. I don't know the full details because we just had a consultation and they're now waiting for me to recommend someone, and I'm going to recommend you guys. This situation is that someone now, and in his case, yeah, he's applied for his TIE. He's married to a Spanish lady, worked in London, but he had a house in Spain, in Marbella. His wife's Spanish. They got a Spanish property. So it was theoretically their main home. He lived half the week in the UK, half the week here. He was flying back and forth. Sort of didn't really know exactly how many days he'd been in one place and one place in the other. But he's been paying his taxes correctly in London, in the UK, because he in his own mind, he's English and he lives in the UK and he's working in the UK, but his wife and his two half English, half Spanish kids are in school over in Spain. Now, he's applied for his TIE, and in the middle of all this mixture, he's received a letter from the tax office. Okay, he applied for the TIE because of all the Brexit, blah, blah, blah. In the middle of all this, we don't know it's been started off because of the TIE or it's got nothing to do with it. But what we know is he's received a letter and they're actually asking him for 142,000 and something euro because they're asking him for 4 years of back taxes for income tax. Okay? What they're saying is that they reckon that he's been living in Spain over half the year, all these 4 years back. They seem to know that he's got a house in Spain, etc. Now, right off the bat, he's made two big mistakes. One, that if he considered himself a non-resident, he should have been filing a non-resident hypothetical income tax return in relation to half the property, which he admittedly has not been doing. And I said, oh, I want to pay it, but now you should have been paying it before. Because by not doing it, you've set off the wrong signal to the tax man.
That's right.
The second wrong signal that he's done is that he joined the padrón in the town hall in Marbella because he said he needed it to put the kids into the local Spanish school. In fact, he could have just had his wife join the padrón, and that set off another second bad signal, because if you join the local electoral roll, it's another signal that you're sort of very much a resident in the area. So immediately, in someone in his sort of situation, I think what people need to know, and in his case, it may have happened anyway, but he was doing two things that were very wrong if he was considering himself a non-resident. One would be to spend more than half a year here, but we don't really know how they've come across that because there was no passport control to that moment. From now on, it would be the case. But he had joined the padrón, and he was not presenting a tax that would have been obligatory if he'd really been a non-resident. So he spoke to us after already hiring a solicitor up in Marbella. He'd visited the tax office together with them, because this guy speaks perfect Spanish because he's lived here. That's why. He went to the tax office and the inspector said, so not worry, there's no problem. You pay us 141,000 something euro, and then you claim it back from the tax office in the UK.
Yeah,
so this man, of course, this is in a very bad problem. He's got a very nasty situation. So I think people do need to just make sure that they're not, they're
doing things right. Yeah,
they're doing things right. I mean, it's such a silly mistake to not pay your non-resident tax. If in reality, especially as you're moving back and forth, hey, don't send the wrong signal off by not paying your non-resident tax, because that's just the wrong thing to say. Don't join the electoral roll in the town hall, because theoretically you should only join if you're a resident here. It doesn't make sense.
But Michael, again, in this case, I would recommend these people to try to speak to the Inland Revenue in the UK. Well, one is to say whether he spent less than 183 days, but the second is see whether the tax office will certify and issue a certificate saying he paid taxes in the UK and he was considered to be taxed.
Yes, he's shown me his tax returns, and he's paid about £180,000 in tax in the last 4 years in the UK, more than we're asking for over here. So yes, I think that's a great thing. That's one of the things he has to do regarding proving that he's been spending almost half the year in the UK. He's going to have a very difficult time, I think, because I think in reality,
Michael, he will have to take the case further. He will have to take the case further through the courts, because he's a lot of money. It's a lot of money, and probably is completely wrong what the tax office is doing. You know, it's fine, they're comfortable here. You know, they're saying, hey, you have a property here, I've got good evidence here, and here is the bill.
Yeah.
And now it's down to you. The burden of proof is yours to say the opposite and prove the opposite. As I said, the only way I've seen taxman to stop and believe something is through a different administration. And we didn't face yet, I don't know if Pedro did face yet, any scenario where he did end up in court, because they did accept it. We managed to stop, Michael, not without stress, obviously, but yes, we managed to do. I don't know, Pedro, if you want to add something to this experience, which obviously is the big worry now. And Michael, another thing, in the old days, obviously, because of the exchange of information between countries, if you read the double taxation treaty, it already says that there is an exchange of information. A lot of people, Michael, they've got all their letters sent to Spain. So let's say the bank will write them to here. The taxman will pay his tax, but will put it, he lives in Spain. And so many evidence. And then, for one way or the other, probably airport control, they didn't have but when you buy a ticket, I'm sure the airplanes and the company, the flying companies here, they will, as Iberdrola does, and the water company, they just provide information to the taxman. So you put them all together in a pot, and here we go. You've got the bill.
Well, yeah, because I think it probably, I mean, even his wife, I was thinking about how they could have found things out. And the thing is, his wife, who works in Spain, she's a dentist, she's probably making her tax return and has been mentioning her husband. And maybe she even said that he lived in Spain. Who knows? I mean, you know, there could be all sorts of little mistakes that have led up to this.
Did it happen, Michael? It did happen to one pilot, a lot of flying with contracts in London, living in Spain, in the holiday home, children here in school, and not even doing, as you said, non-tax return as a non-resident. And here we go. And it was a tremendous work to get certificates from abroad. All that we dealt with, we managed to go through, but a lot of stress for clients, Michael. You could imagine, obviously, for that amount of money.
So with a case like this, it's relatively large for a tax claim. Would you guys, would you be able to sort of go deal with the tax inspector up in Marbella? Would you be able to do that?
I mean, I don't know how far Michael did go through, because at the end of the day, this administrative procedure, we lodge through the appeal, they say no, we lodge the appeal again, they might say no, and then we take it further and further. I mean, the key of the case is having the evidence. I have no problem to go to Marbella, even to speak to the inspector, but sometimes speaking to the inspector, you see how easy it is for them. Just pay. They're not going to negotiate.
So can he organize an initial appointment over Zoom with you? Is that
sure. And we could have either Pedro, myself, and the accountants to look through, and we'll give him his the opinion. But Michael, yes, this is the real scenario that is happening, as you said, for those who apply for the TIE, and now they face the second problem, because the first thing was the immigration, the free of movement, which I agree. But now the second part is now what? So I'm sure, Michael, you deal with a lot of non-residents.
It's nice to know where I can send them then, because obviously we don't deal with these things, and for us it's something we don't know enough about, and you really need someone that just specializes it and can really look into it, because there are lots of clients in not as bad as this one, but there are lots of similar situations.
Okay, right. Let's move on, because we just stuck to. I thought it was good to spend enough time to discuss this point, Michael, because this is really the key I don't know if you're having a lot of questions about these things, but Pedro and myself, we're having a lot of questions about these possible scenario. Now, let's go. We dealt already with Alison. Then we have Alan is saying, I will surely be moving to Spain under a non-lucrative visa. I will be 53 years of age this month and will not be able to draw on my UK SIP. SIP will be his pension until I'm at least 55, but should not need to draw on it until I'm age 60. Will I need to declare my social, what is it, SIPP, probably pension, isn't it? I understand. Will I need to declare my, I understand, Mike, I don't know, Pedro, that will be social security pension. And if so, I will expect to pay wealth tax on it. The pension value is currently in the region of £860,000. Second question, if I may, if my partner and I have sizable savings of say 500 in the UK, is it best to hold 50% in each of our names for wealth tax purposes? We're not married. Okay, well, well, the pension is exempt from wealth here, Alan. So don't mix. Wealth tax doesn't tax the income from salaries and savings. Okay. Obviously, you don't need to worry on that.
Yeah, regarding the 500,000 sterling pounds, obviously, I mean, as is between each other. I mean, will be half of them as test hold 50%. Is that right, Ignacio? That will not be subject also to wealth tax.
Correct.
Also, you cannot. I mean, and the wealth tax also is not included. The permanent home also. So will not be included.
Well, in this community, it's 500,000 euros plus your main property for wealth tax. Obviously, if that doesn't reach the 500,000 euros, they will not pay wealth tax. Now, for the following year in Comunidad Valenciana is 500,000. And
just remind what I said before. I mean, traditional IRA, and there is another kind of fund is like 401k. That one also, both of them do not enter in wealth tax, but Roth IRA, in our opinion, it should enter in the wealth tax valuation.
A good question here, we didn't even touch today on this, is about those people like Alan who are moving over here and they're selling their property in the UK. Okay. I will put in the chat an article about capital gain tax, quite interesting. So we will not drag on too much and try to answer more questions. But it's important for you to sell your main property if you wish to do it now. If you're committed to sell, I always recommend to do it before you're a tax resident in Spain. Even if you're a tax resident, you could do it as long and it will be exempt if you comply with the requirements and you reinvest it, the whole amount of money, etc., etc. I will just post here the article for your perusal later on. Now, let's move on. Pedro, would you like to go with Daryl?
Rapidly, I would say, I mean, I want to be rapid on, I have read 2 or 3 more. Daryl, we are planning to retire in Spain 3 years, so it will be in 2024. We have a new TIE residence card. If we stay in Spain less than 183 days per tax year in 2021, 22, 23, are we still non-resident for tax in Spain? Yes, it's non-resident. It's less than 183 days. And George, that was a good question about George. Thank you, George. Is like 2, I mean, it says 3 pensions, military pension, local government pension, and UK old age pension, UK military pension, and local government pension. Both of them are public pensions according to the double taxation treaty. And so there will be one, which is the old age pension, which if this one is more than 14,000 euros a year, if it's more, then you have obligation to declare. If it's not, you don't have obligation to declare unless you receive some other like income, like for example, interest is, for example. So 2 pensions are exempt, and the other pension, the old age pension, is if it's more than 14,000 euros, you have the obligation to declare. If it's not, there is no obligation unless you receive interest. That's important because, I mean, public pensions are exempt. it is not really exempt, I would say, because what it really means that exemption is that it's going to increase and add this value in order to increase the percentage on the scale. Probably this is difficult to understand, but they will not count in order to be taxed, but it will count in order to evaluate the income to see which percentage is taxed. So it is really that, George. Okay. What else, Ignacio? What question?
One here from John Winderham on the.
Yeah, go on, Michael. Yeah.
I'll go for that one.
Yeah, go for it. Yeah.
Okay, so Mr. John Winderham, if my wife and I both have golden visas through buying a €1 million property, are we treated completely separately for tax purposes? Example, if one of us spends less than 183 days in Spain, but one of us doesn't, what's the tax situation? Okay, John, so if you buy the property together, €1 million, indeed you're entitled to the golden visa each. Then from a tax point of view, you would be treated separately. So for example, if your wife spends more than half a year here, she would be a tax resident in Spain. And if you spend less than half a year here, you would be non-resident of Spain. The golden visa is the one type of visa in Spain that does not presume whether you're a tax resident or not. In other words, you can have a golden visa and spend just one day of the year in Spain and be a non-resident from a tax point of view, or you can spend the whole year in Spain and become a tax resident. The golden visa, what it grants you is the privilege of being here as long as you like. And if you spend more than half the year, you become a tax resident. If you spend less than half the year, you remain a non-resident. And if it's a couple, you can have one being a resident and one being a non-resident. There's no problems.
Again, Michael, as you stated, here is the thing. Again, the immigration side on one side, and then the tax in another. Absolutely. Exactly the same happens with the TIE, with the non-lucrative visa, with the 𝐼𝐸 social ties visa. So yeah, it's quite important to be clear on all these things. Michael, Pedro, would you like to answer any of the fast questions that we're having here? Obviously, we have hundreds here, but we could always, I don't know, we could answer later on.
I've got about 80 unanswered questions coming through on Facebook.
Yeah. I'm reading right now from Sandra. It says that if you, let me just read it totally because I haven't read it. I mean, it's just, do you automatically become tax resident if you have a golden visa and spend under 183 days in the country? This is, I think it's been said right now by Michael, but how much in costs are involved if you sell up your Spanish property for 300,000 euros in Murcia? Would it make a difference if you then use the money plus other money to get a golden visa? And if you went to non-lucrative visa, will you be allowed to rent a UK property? I mean, there's obviously some questions here. I mean, if you stay less than, it says under 183 days, if you stay less than that, obviously you will not become tax resident. If you are not resident on tax purposes, obviously, if you sell the property, will be subject into the situation where the non-resident tax is involved. Depending if which is you are a citizen of European or not, will be in this case the capital gain will be subject to 19 or 24%. And obviously, in order to obtain the golden visa, you need to invest as a minimum on property. There are all the kind of investment on property, at least 500,000 euros. You need to invest. If you reinvest it from some other money that you receive from selling properties, that's perfect. At least you need to show that you invest 500,000 euros minimum. Okay. So it says also, if you went for a non-lucrative visa, would you be allowed to rent a UK property? Perfectly. I mean, obviously, in order to obtain the non-lucrative visa, you have to, as I said, financial means. You need to show that you have enough savings to live in Spain for the period of time that you are applying for, but also you will be able to have some other income from a property in UK or anywhere in the world that will also be added to those savings that you may have as a financial means. Ignacio, I don't know if there are more questions, but I mean, there are a lot of questions to answer. Yeah.
I did publish, Pedro. I did publish here. Well, I would like to congratulate Pedro here. He's being appointed recently the secretary. I don't know if Michael has.
I was going to say that. Absolutely. I've seen it in the press. Well done, Pedro. Well done.
Pedro is the social secretary of the football club here in Alicante. So I'm very pleased. I'm very happy for him. So congratulations, Pedro. I just put the post here as well.
Well, thank you.
I hope you will enjoy this year dealing with the whole thing, and I'm sure we will be together in the football field soon.
Thank you.
Right, Michael, could you please, Michael, give your telephone number loud, because in the panel, some people will miss it, and how, if they are in Andalusia, how they could contact you?
Okay, well, my name's Michael Davies. For those that don't know me, I'm a Spanish lawyer, and we operate in Andalusia. We're in Almeria, we're in Oaxaca, and we're in Marbella. We basically cover conveyancing all over Andalusia, and we handle probate and inheritance related litigation all over Spain. That's basically what we do. My website is daviessolicitors.com, and there you'll find all our details to contact us.
Okay, Michael is he's an ex-honorary British consul, and he's got so much experience dealing with all these British citizens living in Spain. And on the other hand, Pedro, would you like to give your details in case they need?
Yeah, I will put in my email, really, which is pedro@𝐿𝐵heredia.com. I work normally in Costa Blanca, and headquarter office in Alicante, and normally in the north area in 𝐏𝐵𝐸, between Alicante and 𝐏𝐵𝐸. And happy to join this webinar with an expert in the south of Spain, with Michael, and with you, Ignacio. I'm happy to. I mean, there are many questions that I will be glad to be answering, but of course we are run out of time. I understand.
We'll need 10 webinars just to deal with this subject.
There are many questions that are very specifically, and well, I understand the worry of people, but obviously we need 10 webinars to answer. I mean, it's a lot, yeah.
Right, but Pedro, your telephone number, just for those who cannot see the chat.
I will write it in because it's 965-480737, but I will write it in the. Yeah,
because it's going to be recorded, and a lot of people did complain saying we cannot see the chat, so that's why probably it's best if you did say. Right, what we're going to say, I'm very pleased today that we brought up this point, because as Michael stated, we are very confused, or at the end of the day is a very delicate subject on the immigration on one side, the fiscal on the other, and paying social security on the other one. They are there, but they're not connected 100%. So it's always good for you to do simulation, tax planning. You will save money and stress, which is the most important thing. Well, thank you very much. I'm going to pass you over to Juan for now to say goodbye. Thank you, Michael. I hope to see you very soon. Either the same to Pedro. I would love to be outside very soon. And thank you for listening, and see you on the 30th of July on our last webinar.
Thank you. Bye. Bye.
Trust is vital when you're in another country. If you want to buy a home, set up business relationships, or apply for a residence permit, you need to be able to count on the best independent legal aid. Pellicer and Heredia is an international firm of lawyers with over 20 years experience and one single aim: for you to live at ease in Spain. In order to give you a clear, streamlined, and fast response, we work with a cross-disciplinary team of professionals specializing in the main legal fields: civil law, foreigners' affairs, business law, tax and financial law, and international law. And to ensure that you're kept informed and up to date with everything, we have 6 offices on the Eastern Coast. Whether you're from here or abroad, we will always stand by you and speak your language. Our relationship is based on openness, professionalism, and a commitment to finding legal solutions in your best interests and for your peace of mind. Pellicer and Heredia, international lawyers.